All right, welcome back, everyone. Today's explainer is an absolute wild ride. We're unpacking this fascinating piece of alternative historical analysis that claims to expose a massive, buried legal mystery from over a century ago. The source material we're digging into today presents a pretty mind-bending narrative about a forgotten 1916 court ruling. And according to this thesis, this ruling allegedly threatened to tear down the entire modern financial system before it was just quietly erased from the records. So grab a coffee, let's dive right into this and see exactly what this historical thesis is claiming.
The source actually kicks the whole narrative off with a pretty dramatic inciting incident. According to the account, back in the spring of 1916, future Supreme Court Justice Harlan Fiske Stone was reading through this obscure 61-page ruling by a federal circuit judge. The story goes that after reading it twice, Stone supposedly looked up, completely stunned, and said to his clerk, "If they let this stand, the whole thing unravels." But you have to ask, what exactly was the whole thing? And why on earth was a single lower court ruling so incredibly dangerous?
Part 1. The Legal Mystery and a Constitutional Crisis.
Okay, so to really understand why a Supreme Court justice would panic like that, the source argues we've got to step back a bit and look at the context. And what's truly wild here is the sheer speed of how this all went down. I mean, at the turn of the century, the U.S. government didn't even have a permanent federal income tax. In 1895, the Supreme Court actually killed the income tax in the Pollock case. This triggered a desperate, massive push by 1909 to draft the 16th Amendment to make it legal. Fast forward to 1913, and we see this huge dual action event. The Federal Reserve is created, and the 16th Amendment is allegedly ratified. Just 3 years after that, in 1916, Judge Virgil Prettyman issues his explosive ruling. To grasp why income tax was such a huge, hotly contested battleground, we have to look at the arguments from that 1895 Pollock case. The lawyer who successfully defeated the tax, Joseph Hodges Choate, framed it not just as a financial policy, but as a deep philosophical attack. He literally called it a communist march on American property. The justices who agreed with him firmly believed that the fundamental relationship between a person and their wealth was a core pillar of civilization itself. So, the government's grand fix for this was the 16th Amendment, which was theoretically ratified in 1913. But our source brings up some really interesting research from a guy named William Benson back in 1984. Benson allegedly visited every single state archive and claimed the entire ratification process was just riddled with fraud. According to his findings, some states passed completely different versions of the text, and Minnesota never even transmitted its vote at all. The narrative makes a point of noting that instead of just opening the archives to refute Benson's documents, the government actually prosecuted him for fraud.
Moving into Part 2, the pre-constitutional argument.
Which brings us to the man of the hour, Judge Virgil Prettyman, the guy behind that explosive 1916 ruling. He completely bypassed the 16th Amendment by asking a very basic but profound question. What actually is income? Think about your own paycheck today. The modern definition we use is essentially just an accounting trick, right? Money in minus money out. But Prettyman concluded something entirely different. He argued that income is the fruit of your property, and the right to hold that fruit without some sovereign power interfering wasn't granted by the U.S. Constitution. He ruled that it was a pre-existing right, a concept he referred to as an ancient inheritance. So the absolutely crucial question is, where on earth did Prettyman get this legal precedent? And this is where the source drops a major historical mystery on us. To support his ancient inheritance ruling, Prettyman cited 11 precedents. Now, 7 of those were your standard, run-of-the-mill English common law cases, but 4 of them, highly anomalous. He cited something called the Continental Commercial Codes, and he attributed them to the administrative tradition of pre-war Western settlements. The catch here? These codes do not correspond to any known colonial government in the standard historical record. None. And according to his clerk, a guy named Edward Creel, when Harlan Fiske Stone looked at these 4 bizarre citations, he didn't just laugh them off as a typo or an error. The source claims Stone stared at the documents and quietly admitted, "These are real. These are real codes from a real system."
Part 3. The Tartarian Inheritance Thesis.
So if these codes were real but literally do not belong to any known American colonial government, where did they come from? Well, the explainer introduces what's known in alternative research communities as the Tartarian legal inheritance thesis.
Carefully defined, this is the claim that the institutional and legal structures of the 19th and 20th centuries were not newly invented by the founders or the guys who came after them. Instead, this thesis asserts that they were absorbed, heavily adapted, and essentially rebranded from a pre-existing, highly advanced civilization whose history was deliberately erased from the books. Let's actually look at what Prettyman allegedly found inside these mysterious continental commercial codes. According to the thesis, these codes rested on three main tenets. First, property rights were absolute, meaning the fruit of your labor simply could not be taxed away, period. Second, currency was strictly a public utility, explicitly forbidding private debt instruments from ever being used as money. And third, and this is perhaps the most important one, these ancient rights could not be legally extinguished without the explicit, documented, informed consent of every single individual affected.
The logical conclusion that Prettyman supposedly drew from all this is, frankly, staggering. The thesis asserts that the entire income tax system is legally void, not just unconstitutional, but a completely invalid contract right from its inception. Why? Because you simply cannot have informed consent if one party is deliberately concealing material information. If the public was intentionally kept ignorant of a superior, older legal framework that protected their property absolutely, then the new tax was essentially theft by deception. Imagine finding out that the contract you signed for your house or your car deliberately left out the most important page. That's the argument here.
Which leads us to part 4, tying in the Federal Reserves.
Now, you might be wondering, why would the architects of the modern financial system care about one single judge ruling a tax invalid? Well, because the micro connects directly to the macro. The old system, allegedly outlined in those hidden codes, was based on abundance, public credit, and civic authority, with absolutely no private debt used as currency. Economists like Michael Hudson have noted that early economies really did operate very differently from ours today. The new system, the one installed in the early 20th century, is entirely debt-based. It's completely reliant on income tax, private central banking, and government bonds.
And right here is the linchpin of this entire narrative. The Federal Reserve and the income tax weren't just created in the same year by some fluke coincidence. The source heavily argues they are a tightly interlocking system. You see, the Federal Reserve issues debt-backed currency, but it desperately needs a reliable, constant stream of income tax revenue to serve as collateral for that debt. So if Judge Prettyman was right and the income tax was legally void from day one, then the entire Federal Reserve System was issuing dollars backed by absolutely nothing. And that right there is exactly why Harlan Fiske Stone allegedly panicked.
Part 5. The alleged cover-up.
So think about it. If a federal judge just discovered a legal thread that could literally unravel the central bank and the modern tax system, what do you think happened next? The source details this incredibly rapid systemic suppression. Just look at how fast this timeline moves. The ruling drops in March 1916. Within just 10 days, the Justice Department rushes in and files an emergency appeal. Within 3 weeks, the case is transferred completely out of Prettyman's jurisdiction. And just 6 weeks after handing down the decision, a perfectly healthy 51-year-old Judge Prettyman resigns from the federal bench entirely, moves to a small town, and never practices law again.
The source claims this erasure was absolute. I mean, when Prettyman died in 1931, his obituary completely omitted his time as a federal judge. It's like it never happened. We apparently only know about this suppression because of fragmented evidence, things like private letters from a journalist named Victor Rosewater, who allegedly predicted the establishment would crush Prettyman, and an unpublished 1958 memoir with a clerk, Edward Creel, finally detailed Stone's terrified reaction to those buried codes. To explain exactly who had the kind of power to execute a cover-up like this, the thesis points the finger at Paul Warburg. Now, Warburg is a very historically documented figure, widely known as a primary architect of the Federal Reserve Act that was drafted in secret at Jekyll Island in 1910. But the source highlights something really specific. His banking family had deep historical ties to the exact European continental trading cities where these older commercial codes supposedly originated. The huge implication here is that Warburg knew exactly what legal framework he was quietly replacing.
Which brings us to the ultimate question, right? Where is the evidence today? The source actually traces the supposed documented chain of custody of these missing continental commercial codes. If you check standard U.S. libraries, the citations simply do not exist. There's a private society in Philadelphia that holds pre-revolutionary documents, but access to them has allegedly been highly restricted for decades. Finally, the source claims that the original pre-modern European administrative texts are sitting right now in a charitable foundation in Basel, Switzerland. And guess what? That foundation was notably established in 1921 with major donors from the Warburg family. And this brings this whole historical mystery right up to the modern day. The narrative asserts that the physical evidence of this prior debt-free civilization and its absolute property rights isn't actually destroyed. It's simply being gate-kept. The codes are allegedly sitting in that Basel archive right now, just waiting for a time when the public consciousness shifts enough that the concealment of this ancient inheritance can no longer be maintained by the institutions currently in power.
And that really leaves us with a profound thought to chew on. Regardless of where you personally stand on these alternative historical claims, the source poses a truly fascinating hypothetical about power, consent, and the stories we are told about our own institutions. If a foundational thread of our economic reality was deliberately severed a century ago, what actually happens to the financial architecture of the modern world when someone finally pulls it? It's an incredible narrative to explore for sure. Thanks so much for joining me on this explainer, and as always, keep asking the big questions.